Hi, my name is Goldman. I'm an attorney with Goldman & Associates, and we're continuing our discussions about property aspects in divorce. Please subscribe to our channel. A client recently asked us a question about whether or not if they inherit something during the marriage, does that become a marital asset? Does it somehow become joint, and if there's a divorce, do they forfeit half of it? It's actually a very good question. It goes to the interplay between inheritance rules and divorce rules. In general, this is how it works. If you inherit something, the law at its outset recognizes that item is yours. It belongs to you. It's the fulfillment of your dad's last will and testament that you get that item. You don't have to split it with anybody. But if you do, it's only going to be because you exercise the discretion to do so. So you're going to get the item. The item's, let's say, a piece of real estate. That belongs to you. If you keep the item that belongs to you, titled to you, separately as a result of the inheritance, and you never commingle it into your marriage, odds are the court's going to look at that in a later divorce and say, well, that's off the table. That item was yours. You inherited that item. We're not even going to talk about that. We're going to talk about the other things. However, if at some point in time you choose to commingle that item into the marriage, you are making a gift to your marriage of an item that was originally yours. It's the nature of any gift. A person has something that belongs to them, give it to another person. In this particular case, if you inherit $100,000 and you keep it in a separate account, it's yours. The minute you take that money and put it into your account joint with your wife, you've made a gift to the marriage. And more likely than not, the court's going to look at it as a marital asset. If you want to keep the corpus of the item that you inherited and you want to keep that always as separate, then do that thing. Keep it as separate. Open up an account in your own name. You can call it proceeds from my inheritance and keep it, everything you inherited, keep it in that account. And if you do it that way, more likely than not, the court will see that the lines are very clear. This is yours, this is marital. As soon as you start commingling things, you start blurring the lines. When you take that piece of property and you decide that you inherited it, but now you're going to refinance it, and now it's in both names, you've really blurred the lines, and you've created a scenario where the court may very well view that as marital property. If you have any questions about that, reach out. I know it's complicated, and of course, we'll be glad to help you out.